the Skilling case and then bring you up to date with the subsequent Johnson case. They're both very recent cases. The Skilling case was the prosecution of the United States v. Skilling for honest services. It was, they indicted a prominent executive for failing to render honest services to his company on the grounds that he had misstated the value of the stock. He had a whole bunch of the stock overstated and sold with a huge profit for himself. And the United States Supreme Court said is that federal statute that prohibits makes an unlawful act to fail to render honest services to your employer, is that constitutional? Over Justice Scalia's dissent, the majority said that it was constitutional for one reason. We have a historical background of prosecuting people for bribery and kickbacks. As long as you limit it to bribery and kickbacks, because there are tons of cases holding that briberies and kickbacks are unlawful, then the statute can be held constitutional. Justice Scalia wrote a dissent and said, I don't care how many cases there are, if the statute is vague and you can't tell what they meant, then it's unconstitutional. It's unconstitutionally vague. And then that brought us up to the Johnson v. United States, which is the most recent statement by the United States Supreme Court, where Justice Scalia's view carried the day. And the question in that case was a statute which enhanced the sentence of a person if it were a, quote, crime of violence. And Justice Scalia pointed out that what do you mean by a crime of violence? I mean, that could mean that he was an accessory to violence. Or some people might consider armed robbery to be a crime of violence, and others might say it's not a crime of violence because there was no violent act. The dissent in that case claimed, well, maybe so, but there are certain acts that are, can be lawfully prohibited. And Justice Scalia's majority opinion for the United States Supreme Court said that won't do it. The fact that there are certain acts that could be made unlawful. For example, let me use your obvious example. For example, it might be possible to write a statute and make it unlawful to use the grand jury to intimidate an assistant United States assistant attorney general. But if the statute is so broad that it encompasses legal acts, according to Justice Scalia, then the statute is unconstitutional. This statute, Your Honor, obviously encompasses legal acts. It is legal. It is well established that Mr. Smith or any other district attorney can go to a co-conspirator and advise him, I tell you what I'll do. I will give you special consideration of leniency if you'll testify truthfully to us. If you don't do that, the maximum sentence for this is liable to be 50 years in the penitentiary. Or this may be a capital murder case, and you're one of 3 co-conspirators. You testify against the others, and I think it is unlikely that you will get the death penalty. That's just an inherent part of plea bargaining, is to advise a criminal defendant. So there are acts that are within the statute. Your Honor, another important aspect of this, and that's what in the Johnson case.
Is there a distinction when the prosecutor does that with defense attorney's counsel versus having a private meeting with the defendant himself?
Yes, sir. Now, my point, no, sir, I don't think there is. Let me point this out. In this very case, that's one of the things you can put on proof. If you're not allowed to put on proof, I believe we will prove that Mr. Johnson did not have counsel. That either his attorney general or the U.S. attorney went to Johnson, and they
whether Mr. Johnson had counsel totally irrelevant.
In this particular case, Your Honor, either the FBI or these attorneys or both would have to get Mr. Johnson on the stand to figure this out. Had to have advised him as to how long he could go to jail for bribery in the federal courts if he didn't act as an informant. They weren't dealing with any counsel because he didn't have counsel. So they had to have advised him directly. So I absolutely do not quarrel with the fact that you could write a constitutional statute. But I'm saying this one embraces acts that are clearly lawful and protected, and it's therefore unconstitutionally vague, and it does not do. The court can't be the legislature. That's one thing Justice Scalia pointed out. The court enforces the law. Your Honor can't write a constitutional statute for them or make an ex post facto decision. But I think under these facts that this was an unlawful act. We have to look at the face of the statute and determine whether or not this statute embraces acts that are clearly lawful. And it does, because plea bargaining and advice of criminal defendants is a lawful act. Your Honor, here's another important point that we have not briefed, and if the court were to entertain briefs on this after this motion. This statute, and there are law review articles on this statute was passed passed back at the time when we had part-time district attorneys. In fact, they were all part-time. It was never repealed when we went to a full-time district attorney. There are a lot of new articles that talk about part-time district attorneys and how the prohibitions against them also practicing law. I think a compelling case can be made. What the legislature intended when they passed this was to have these part-time district attorneys not also practicing criminal law on the side. Unfortunately, they didn't repeal the statute when in 1992 we went to full-time district attorneys. But in Mississippi, I'm certain, and I feel confident nationwide, there's no such thing as a criminal prosecution or a district attorney aiding a criminal defendant. There's just no such thing. This case is novel and unique. And it could come up, back at the time it was passed, if Mr. Smith was a part-time district attorney and he was out practicing law on the side and competing with defense attorneys. I think that's probably what it was designed for. But regardless of that, it is certainly unconstitutional vague as we play it in today's society because Mr. Smith, he has a duty. I brought a number of cases, but he has a duty to protect the rights of the accused. And, Your Honor, I have some cases I'd like to leave with the court, but that's the essential. That's the basis of our argument is unconstitutional vague. Now, let me mention an aspect of our motion that we would need proof on. There are numerous cases, Your Honor, just a couple of which are cited, I believe, but there are numerous cases saying that a prosecutor cannot have a personal interest in a case. That is, a prosecutor is supposed to be an advocate. If the police bring him an armed robbery case, he doesn't know the victim, he doesn't know the accused, and he is simply presenting a state's case and arguing for a conviction. That's perfectly appropriate. But if he has a personal interest in the case, in this case, we will offer proof that Mr. Smith was arrested within a day or two after it was reported to the Attorney General that Robert Smith was investigating two Assistant Attorney Generals. And we think they probably feared that they were going to be indicted, but that he was arrested a day or two after that. I don't see how the Attorney General does not have an interest in this case. Judge Will on June the 23rd disqualified Mr. Smith from all of his activities and went into a well-written, detailed order about all the wrongdoing Mr. Smith had done. It's almost inconceivable that the Attorney General was not giving him that information. He wrote a very detailed, well-written opinion in the course of one day otherwise. But we think the Attorney General has a personal interest in this case, which is to protect his two assistants or make it show that they weren't doing anything wrong. And the appropriate procedure would be, Your Honor, to appoint an independent prosecutor, that is, some lawyer, who has no interest in this one way or the other. He's not trying to protect any of his assistants. He only has an interest in determining justice, but he has no personal interest. But the Attorney General has a strong personal interest in showing what my assistants didn't do anything wrong and in keeping them from appearing before the grand jury. It would be, I would think that it would be very harmful to Mr. Hood to, if it turned out they did do something wrong, it would be a poor reflection on his office.
I'm going to object. It's irrelevant comment. This is a comment that's made for the cameras. You can stick to the focus on what we're dealing with today.
Oh, proceed.
I would like to leave forth the cases that say, North Mississippi, from out of state, that say the prosecutor, Your Honor, has to be impartial. He can't just. There's a U.S. Supreme Court case where the state appointed a special prosecutor, a victim of a crime. There was this manufacturer, and they had some employee that was stealing from them. The local jurisdiction appointed the victim, the lawyer for the victim company to be the prosecutor. The United States Supreme Court said that was unconstitutional. A DA has a duty to be impartial. That is, not impartial in the way a judge does, but he can't have a personal interest in the way a case comes out. And the Attorney General has an absolute personal interest in this case and in convicting Mr. Smith. When they arrested him, it disrupted the investigation that he was undergoing. And he has an interest in seeing Mr. Smith is disqualified because the investigation at that time was stopping his investigation doesn't go any further.
Counsel, if I agree with your argument, who would you suggest get appointed to be a special prosecutor? On top of that, what authority is there to have that person compensated?
Yes, the statute speaks to that. And that's one reason I think the statute didn't contemplate the Attorney General. I have a statute But it says that the attorney is compensated from the district attorney's salary. That's what it says. But it wasn't, the statute apparently is not addressing the situation where it's the DA who's the person being prosecuted. But it's obvious the statute did not contemplate the Attorney General because that's the way it provides compensation. If the Attorney General was supposed to be the special prosecutor, we know he's already paid by the state. So I think that's an issue we have to deal with as to how he's going to be compensated. But we believe the statute does not allow the Attorney General to be the special prosecutor because it talks about compensation. So he has to be, I think the appropriate thing is, I think a special prosecutor should be appointed in this case, Your Honor, to look into Mr. Smith and see if he's committed some criminal action. And also to look into what's going on with these attorney generals and whether or not they in fact threatened Mr. Buck, whether they did it or not. I've never talked to Mr. Buck, so I don't know. But it all needs to be looked into. And the Attorney General has an absolute interest in this case in getting Mr. Smith convicted of personal injury. So it should be an independent prosecutor, and Mr. Smith would be comfortable of having a case presented to the grand jury by a lawyer in this case that Your Honor should select, who's fair and impartial, and then we can try to decide among ourselves if we can agree on the compensation. But we don't think it should go forward with an empty prosecutor.
Right. I want to hear from the Attorney General on the motion for
Yes, Your Honor. I have to say, I do find it a little bit ironic to hear Mr. Wade arguing about the impartiality of the prosecutor when one of the charges here is his client advising, counseling, and meeting privately with a criminal defendant, which certainly goes beyond being an impartial prosecutor. But now, as to the two conspiracy counts in this indictment, Your Honor, the indictment plainly and completely tracks the statute. 97-1-1, and it alleges that these two defendants conspired with each other to commit the crime of hindering prosecution in the first degree. That is what the law in this state requires us to do. That is what the Supreme Court said in Berry in overruling the Court of Appeals, which had said that an indictment did not properly charge conspiracy. The indictment tracks, those two counts of the indictment track the statute. They give the defendants notice that they are charged with conspiracy to hinder prosecution. And the indictment even says hindering prosecution by conspiring to hinder the prosecution, conviction, and punishment of Christopher Butler. It identifies the case in count 1 and it identifies the case in count 2. Our position on the two conspiracy counts is that we have complied with the law, we have complied with the uniform rules that the requirement.
Let me stop you there. Rule 706 said that the indictment shall fully notify the defendant of the nature and the cause of the accusation. It also says it shall be a plain, concise, and definite written statement of the essential facts constituting the offense charged. The indictment does not specify on count 1 and count 2 whether the conspiracy was to violate subsection A, B, C, D, or E of paragraph A of 97-9103. My question is, how can Mr. Smith know of the essential facts constituting the crime of conspiracy based on the language in this indictment? In other words, what specifically did they conspire or did he conspire to do?
They are charged with specifically between December, the date, time, the place. Those are the essential facts, part of the essential facts. Between December 1st and June 22nd, 2016 in Hinds County, conspired to commit the crime of hindering prosecution. That's the essence of the conspiracy.
And to commit the crime of hindering prosecution, he must have, quote, rendered criminal assistance, correct?
If we were charging him with the crime of hindering prosecution, correct.
He has to have rendered criminal assistance. Are you claiming that Mr. Smith harbored or concealed another person?
We're not, Your Honor.
Are Are you claiming that he warned another person of impending discovery or apprehension?
We are not, Your Honor.
Are you claiming he provides or aids in providing the other person with money, transportation, weapon, disguise, or other means of avoiding discovery?
We are not, Your Honor.
Are you claiming he prevents or obstructs by means of force, deception, or intimidation anyone from performing an act that might aid in the prosecution and conviction of another person? I assume that's where you're traveling.
That's the theory of our case, is that he did all that he could, he and Mr. McBride, to bring to a close, to prevent and obstruct the prosecution of Christopher Butler in 2 cases.
And those 2 cases are the 2 marijuana possession over a kilo cases.
And the fraud case.
And I assume the first 2 marijuana cases relate to Judge Will's subpoena before the grand jury, and primarily. And the fraud or wire fraud case and embezzlement case relates to the 2 assistant attorney generals being subpoenaed before the grand jury to intimidate them, if you will, or drop those charges against Mr. Butler.
Well, and also showing up at the preliminary hearing on those charges and asserting that he had some authority in the case that had already been commenced by the Attorney General's office and did not require the permission of the District Attorney's office to initiate those fraud charges.
Well, that's what I'm trying to ask. How does Mr. Smith know, as a criminal defendant, what the essential facts are that constitute the offense that you charged him with of impeding a prosecution or rendering criminal assistance? How does he know?
Your Honor, he doesn't have to know the essential facts of the underlying criminal charge. He has to know that he is charged with conspiring to commit that crime. That's all that we charge in counts 1 and 2.
What do you charge me and Mr. McBride with conspiring to do?
To hinder the prosecution in the first degree of Christopher Butler.
Did they buy Mr. Butler a plane ticket to South America?
No, Your Honor. We'll show that our theory rests on the language in 979-103D. But our position is we don't have to put that in this indictment.
I always feared this, and I have to say it publicly. When I retired, some lawyer would quote a case that I wrote as a judge on the Court of Appeals as authority, and you have done so in the Berry case, I noticed. Do you take that Berry case to be controlling in this situation?
Not by itself, Your Honor. There are the Thomas case, the Sanderson case, there are a number of other cases where the Supreme Court has addressed what is required to charge a conspiracy. And our position is that we have met those requirements. I'm looking at the improved jury instruction on the charge, and it says, essentially, the state's not required to prove they entered into some oral written agreement, the details of the plan, the means by which the plan was to be carried out, or the specific part to be played by each conspirator. That's what the defense is asking us to do. They're asking us to detail the plan when the charge is the plan itself. The agreement to commit a crime is the crime here, and it is properly charged in this indictment. That's our position. Now, the proof
problem to me with the Berry case had much to do with the fact that the attorney in that case, defense attorney, never filed a motion to quash. The jury was in panel, jeopardy attached. He waited until the state rested his case and then made an oral innocent motion for the first time, claiming that he didn't know what his client was charged with because the indictment was legally insufficient. And I felt that the timing of that was highly suspect. If there was a problem with the indictment, bring it up before trial. Possibility exists the grand jury could reconvene and correct any deficiency, and jeopardy would not attach. But in that particular Berry case, that's not what happened, and that was, to say the least, troublesome to me for the lawyer to wait until the case was, state's case was concluded before he made a complaint about the legal sufficiency of the indictment. But that's not what the Supreme Court said. They simply said that conspiracy at least the majority said the conspiracy indictment was sufficient on its face.
Yes.
Even though it did not, it charged possession of precursors, which is not a crime standing in and of itself. It's possession of precursors with intent to manufacture methamphetamine that is the criminal offense. And they held the conspiracy count legally sufficient and overruled the Court of Appeals majority. All right, anyway, go ahead.
Your Honor, as to count 3, the charge under 9711-3, Mr. Wade suggests essentially that it's vague or it's overbroad. At least that's the way I understand his argument, essentially. Now, let me say first of all that what the Supreme Court said in Johnson about what is a crime of violence and how that needs to be defined in the statute has no bearing on what this statute means and what a person of reasonable intelligence or common intelligence reading it would understand it to mean. So the Johnson case I don't think has any bearing. Mr. Wade also cites the McDonald case, which is a case that dealt with another federal statute, Title 18, Section 201, which is a bribery statute. And there, the Supreme Court was dealing with what constitutes an official act for which there can be a quid pro quo relationship. Again, that has no bearing on this statute, 9711-3, and so McDonald doesn't have any bearing. The quandary, or at least the continuing dialogue, if you will, the Supreme Court was having about what the honest services statute means, that's Title 18, Section 1346, arose out of the fact that until the McNally case, we didn't have an honest services statute. It was in relation to, or in response to the McNally decision from the Supreme Court that Congress passed Title 18, Section 1346, and said that you can commit mail fraud by depriving your employer, for example, of the right to honest services. Again, that is far afield from what we're dealing with here in Section 9711-3. And I would simply read the pertinent language says, any district attorney shall, if any district attorney shall in any manner consult, advise, counsel, or defend a person charged with a crime, then he is violating.
Does that mean when the district attorney bumps into a person who's charged with a crime that does not have an attorney, and the district attorney says, hey man, you need to get yourself an attorney, has he committed a crime?
I don't think he's consulting, advising, or counseling at that point, Your Honor.
He's advising them to go get a lawyer, is he not?
Every defendant who appears in court without a lawyer is advised to get a lawyer, Your Honor, by the prosecutor.
What I'm saying is the Constitution, to that extent, trump this statute.
I think in regard to the prosecutor's duty to assure that the defendants have counsel, yes. But it's the context in which this conduct here, and what's charged in count 3, is in effect, Mr. Smith went to the jail and appeared as an attorney in effect for Christopher Butler. That's well beyond just bumping into somebody on the street. That's going to the jail, asking to see his client, who happened to be under indictment by his office and by the Attorney General's office at the time he's appearing at the jail without counsel. This business about what he can do to make plea agreements or to get cooperation from defendants. Nobody disputes it. The Attorney General's office certainly doesn't dispute that any prosecutor can do that. We do it routinely ourselves through the offices of the defendant's counsel, not directly. I couldn't go to any defendant who's under indictment and meet with him at the jail and say, I want to get you to cooperate. I would be violating the statute if I did that. I couldn't go to the defendant in the jail and say, you know, you could get yourself a lot of help if you just talk to us. Without his counsel, I would be violating this statute. And this is not a complicated, the language of the statute is not complicated. A person of reasonable intelligence who reads the statute can understand what is prohibited. It does not prohibit a prosecutor, district attorney, from doing his duty on behalf of the people who elected him. but it does prevent him from stepping over the line and becoming, in effect, an advocate for those whom he is charged with prosecuting. That's what we allege in count 3, and we believe it is entirely supported by the statute. The statute's not vague. The statute doesn't chill any significant amount of the district attorney's function as a district attorney. And in that regard, we don't believe there's any constitutional insufficiency or constitutional failing with section 9711. Thank you, Mayor.
I just very briefly point out something in Ms. Johnson's budget report.
Yes, sir, you may respond.
Your Honor, counsel's argument that there's certain things you cannot do. That's what he wants to distinguish. He says, well, of course, you can tell an indigent defendant when he gives you counsel. But he says there's a line that has to be drawn, and Mr. Smith has gone beyond. Well, that very point is what Johnson addressed. And I'm reading from Justice Scalia's opinion on page paragraph 11, and I'll hand it to the court. All those statements and some of our opinions could be read to suggest otherwise. I was always squarely contradict the theory that a vague provision is constitutional merely because there is some conduct that clearly falls within the provision's grasp. For instance, we have deemed the law prohibiting grocers from charging an unjust or unreasonable rate for the vagueness, even though charging someone $1,000 for a pound of sugar would surely be unjust and unreasonable. In other words, the fact that the Attorney General can come up with certain things and maybe the court can, and say, well, I think that act is within the statute, that doesn't say the statute. The statute clearly takes into account, would make it illegal to advise a criminal defendant to do anything, and it is void for vagueness. And it also, Your Honor, puts this court in a position of being a legislature. Your Honor decides as a legislator, well, what act is in, and that's not the role of the court. The legislature has to define criminal conduct. Could I just lay before this?
You argue strenuously, Mr. Wade, that the plain reading of this statute does not permit an ordinary person, a reasonable intelligence, to understand what is prohibited. Right?
That's one part of our argument. The main part is that it takes in, it criminalizes certain things that are clearly lawful. That's the main part. It criminalizes the act of plea bargaining, for example. That's a clearly lawful act.
The Attorney General and District Attorney are supposed to be representatives of the state, the public as a whole, to prosecute those individuals they believe, based on the evidence, most likely guilty of a criminal offense. Their client, if you will, is the people.
Yes, sir.
This statute says whenever a district attorney consults, advises, counsels, or defends a person accused of a crime, he stepped over the line.
Which would make plea bargaining over the line.
I understand that, but can an ordinary person of ordinary intelligence understand what this statute is intended to address?
Yeah, I would say that aspect of it is, if Your Honor's correct, that aspect of it will not be violated. The aspect of it that is violated is the fact that the statute embraces acts that are clearly legal and lawful. It criminalizes lawful acts. It's overly broad. I think you can make a compelling argument that tell them, you know, I tend to agree with Your Honor. That means you can't go advise a criminal defendant. So that aspect of it passes constitutional motion. The part that does not is that it makes certain acts which are clearly legal, clearly lawful, to be illegal criminal acts. It's unconstitutional on its face. And this is what Justice Scalia, Your Honor, of course, found out the latest pronouncement of the United States Supreme Court, and this did. And it certainly criminalizes.
But your burden is to convince me of that beyond a reasonable doubt, correct?
That's correct. That's an interesting question, but under the Mississippi Supreme Court jurisprudence, yes. But we're dealing with
Under Mississippi Supreme Court, before a trial judge should sit here and declare a legislative enactment passed by the legislature up the street to be in violation of our Constitution, you got to convince me beyond a reasonable doubt that it fails.
Yes, sir. I might make this caveat. That's what the Mississippi Supreme Court has plainly said. But as a matter of federal constitutional law, I'm not aware of that standard being used. So I frankly question the correctness of that, because I don't think the United States I don't think the federal courts have ever held that to be a standard as to federal constitutional questions. As to state constitutional questions, there's been no question. We're in here with the federal constitutional question, and the only issue is whether does this act embrace matters that are clearly lawful. Let me give you, this is remarkably analogous to these honest services statutes that the United States Supreme Court has dealt with. It's very analogous. For example, if they had said Mr. Butler got paid by Mr. Smith, or Mr. Butler paid Mr. Smith to get him out of trouble, then that would, clearly fall in the bribery cases, clearly unlawful. If they had alleged that Mr. Butler had some prior family connection with him, and that he took it as part of his job duties, there may be some, because of friendship to Mr. Butler, that might violate some statute. I'm not clear. But just the fact that he assists in coming within that statute is on its face unconstitutional. I'm certainly not saying there may not be some statute they can charge him with, that an impartial DA could go to a grand jury to get a proper indictment. I'm simply saying that this statute that they've invited Mr. Smith on is plainly unconstitutional.
If you have copies of those cases you're relying on, President, I would like to see those.
Johnson case is primary. And I've got several opportunities of DA to be not interested in the outcome of the case.
No, also to just point out, it's cited in our response. The real question is whether the statute goes too far. Because as the Supreme Court said in Village of Hoffman Estates, the court first tasked it to determine whether the enactment reaches a substantial amount of constitutionally protected conduct. If it does not, then the overbreadth challenge must fail. The fact that it may touch on some activity by the district attorney is not enough. It's got to touch on a substantial amount of protected constitutional action. This statute doesn't go past that.
I read your response brief to that motion. All right, gentlemen, it's the court's considered opinion that this indictment withstands legal scrutiny regarding its sufficiency on count 1 and count 2, the conspiracy charges, I think, are sufficiently described to state and set forth to the defendant the essential facts that constitute the essence of the crimes of conspiracy. So, with utmost respect to both defendants in this case on those grounds, and then deny your motion. I do, however, will entertain the opportunity to read some of these cases that are now being presented to me and reserve the right to change my opinion prior to the jury trial. But at this time, I'm overruling on count 1 and count 2. Count 3 is a constitutional challenge to the misdemeanor charge allegedly advising a criminal defendant in violation of Section 9711(3). In order for this court to hold a duty enacted statute of legislation to be unconstitutional based on vagueness or overbreadth, I have to be convinced beyond a reasonable doubt that it is unconstitutional. The statute prohibits an attorney general or district attorney from consulting, advising, counseling, or defending a person charged with a crime. In my considered judgment, reasonable people of ordinary intelligence can understand what that statute is intended to reach, in other words, what type of conduct. Unquestionably, there are some areas where a prosecutor could technically be guilty of violating the statute that are constitutionally protected acts by a prosecutor that, in my judgment, would not render that person subject to being prosecuted. But overall, I think this statute is sufficiently worded to advise reasonable people of the type of conduct is prohibited by prosecuting attorney, the attorney general, or district attorney. So it's my judgment that the motion on count 3 should likewise be denied. Gentlemen, we have been going now for a little over an hour. I'd like to take about a 10 or 15 minute break, give you an opportunity to collect your thoughts and deal with the other motions. There are numerous other motions dealing with discovery, and reconvene in about 15 minutes and try to address the other